May I proceed?
You may proceed.
Good morning, Doctor.
Good morning.
How are you presently employed?
I'm the Chief Medical Examiner for Orange and Osceola counties.
And how long have you held that job?
I've been Chief Medical Examiner since 2004.
Prior to being the Chief Medical Examiner for District 9, where were you employed?
I was a deputy chief for a little less than a year, and then I was employed as a medical examiner in Bexar County, which is San Antonio, Texas, for 10 years, and prior to that, in the metropolitan Atlanta area. And I've been a medical examiner also in Jacksonville, Florida, and I trained as a medical examiner in Miami.
If you could just take us through your educational experience that led you to your work as a medical examiner.
Sure. I'm a MD, medical doctor. That degree was from St. Louis University in St. Louis, Missouri, graduating in 1982. I then did my internship in internal medicine at the University Hospitals in St. Louis. I then specialized in pathology, both anatomic and clinical pathology. Anatomic pathology is basically the doctor at the hospital that looks under the microscope, does hospital autopsies, diagnoses diseases, and I'm board certified in that. That training was at the University Hospitals in St. Louis. I'm also trained in clinical pathology. That is basically the doctor that runs the laboratories. I'm board certified in that. I then subspecialized in forensic pathology. That is the field of pathology that specializes in why people die suddenly and unexpectedly, and it deals with ballistics through the body, it deals with injury interpretation. And that training was in Miami, 87 and 88, and I'm board certified in forensic pathology.
And after your educational experience, you became a medical examiner. You've told us where you've worked.
Yes, I just...
All right, taking us to today. Now, did you have occasion to become involved in the investigation of the death of Caylee Marie Anthony?
Yes, that came under under my jurisdiction.
Now, when did you first learn of the possibility that the remains of Caylee Anthony had been found?
That would have been on the 11th. I don't remember the time. Sometime in late morning, early afternoon.
Were you alerted by law enforcement?
I was alerted by my chief investigator, Steve Hansen.
Upon learning of that, what did you do?
And I was late for the airport. I had already left the building, had run back in to pick up something that I'd forgotten. As I was walking out, Mr. Hansen told me that they had found the remains. And we weren't sure who that is for sure at that point. Oftentimes these scene recoveries take a long period of time. I had a engagement that I could not get out of. I was late for the airport, so I immediately contacted Dr. Utz and told him to initially handle it till I got back. I would be back the next day. I told Steve to make sure that Dr. Schultz was called. He's my anthropologist that's our consultant. And I believe I might have even talked to Dr. Schultz myself. I can't remember, but I made sure he was involved and I made sure Dr. Utz was able to handle it. I thought that initially, typically how we handle skeletal cases is that it takes a while for the recovery. They're brought in, they sit, and then we analyze. And it's a long process. I didn't think my absence for the night would matter.
Sure. Now, when you returned, you returned the following day?
Yes, that was Thursday. I returned Friday evening.
When you returned the following evening and for the days and weeks after that, did you go back and review the photographs that had been taken both at the scene prior to the skull's removal and those taken at your facility while you were gone? Have you reviewed all those photographs?
Absolutely.
Now, once you arrived back and took the case back from Dr. Utz, did you continue to investigate and photograph additional items that were taken with the body?
Yes, I did. Case was discussed. I went out to the scene. I reviewed all the photographs. I made some suggestions for what else needed to be done, and made sure that we got some other different other consultants in also.
Just a moment. If we may start by showing the witness State's Exhibit CX in evidence. CX. I think you might have to. It doesn't really matter. Is one of the things that you examined when you arrived back the hair mat which was surrounding the skull?
Eventually, that hair mat came back to me. It was sent to the FBI, and I asked for that back.
All right.
And that was sent back to me, and I examined it then.
Is this a photograph that was taken before it was that you reviewed, or was this one that was taken after it came back?
Looks like there's bone. It's oftentimes when you show me one picture and it's not in context,
Sure.
It's difficult to say, but it looks like there's still bone attached. So,
Would this have been one of the photographs you reviewed?
oh, this would have been one that I reviewed, certainly.
All right. Let me go to photograph CY. Again, is this a photograph that you took or reviewed?
Yes.
All right. At this time, I'd move into evidence States Exhibit CX and CY.
What says the defense? Be receiving evidence, the state's numbered.
Yes, will become state 250, CY will become state exhibit number 251.
Let's start with formerly CX. We published that to the jury.
Okay, publish.
All right. Doctor, can you tell us what we're looking at in this photograph?
We're looking at the hair mat of the decedent of the case 81567.
What else do we see in the photograph other than hair?
We see a lot of the roots that have grown through the hair.
And now if we could see what was CY. And this is in evidence as 251. And again, what are we looking at here, Doctor?
We're also looking at the hair mat. We're also looking at the roots that have grown completely through the hair mat, and we're also looking at some holes. I don't know if you can. Holes in the hair mat, probably from insect activity.
Let's unpublish to the jury and move on to DA. You recognize this photograph?
Yes, that's a photograph that we teased out some of the hair to take as a sample. This was teased out from that hair mat to take as a sample for possible toxicologic use.
Right. And does this photograph also show a scale showing the length of the hair?
Yes.
This time you ought to move into evidence States Exhibit DA.
It will be received in evidence, states numbered. You want to publish?
Yes, please. Again, the scale that you have here is to change my glasses, I'm sorry, 6-inch scale?
Yes.
All right, so this would reflect the length of the hair being at least more than 6 inches.
That is correct.
All right, thank you. All right. And we may unpublish, Judge? Yes, we're finished. I'm sorry, I said we may unpublish. Thank you. And if we could have DC in evidence. And you recognize this is one of the photographs taken either at your direction or by your office.
Yes, that was actually taken at my direction. Again, a hair, that's the scale next to one of the roots on the hair mat.
This is just, and the scale, the purpose of the scale is to allow someone to compare the size of the root with a scale in the same
Correct.
picture. This time, got to move into evidence, States Exhibit DC.
Be received in evidence as states numbered. Publish.
Yes, please. That's fine, Your Honor, we can unpublish now. Now, some of the items that were found with the remains, did you examine and separately photograph a number of those?
Yes.
I want to specifically ask you about a blanket. You recall there being a baby blanket that was found,
Yes.
right? And did you have that photographed?
Yes.
This time, could we show the witness DV? Do you recognize this as a photograph of the blanket taken at your direction?
That was either taken at my direction or by someone in my staff. It's been photographed, it was photographed several times.
All right. This time, you ought to move into evidence, States Exhibit DV.
Be received in evidence as states numbered.
May we publish? This particular blanket, this is the condition that it came into your office. Is that correct? Hasn't been cleaned or anything like that?
It was not cleaned or it was just kind of unfolded.
Are there certain portions of this blanket where you can detect some figures?
Yes.
Did you ask your staff to did they take a closer photograph to show those figures more clearly?
I might have even taken that photograph. I remember taking some, yes.
All right. If we could unpublish the jury, which I've done, and show the witness DW. And you recognize this photograph, DW?
Yes.
And is this the closer photograph trying to show the figures on the blanket?
Yes, it is.
And this time, you got to remove evidence, States Exhibit DW.
Any objections? Be received in evidence as states numbered.
And may we publish?
Publish.
Now, I'm going to ask Mr. Perez to zoom in on this figure. When you viewed that figure, did it look familiar to you?
Yes.
Who's that?
Winnie the Pooh with Piglet on its back.
Thank you. We're all done with that photo. If we could show the witness DX. And is this a photograph of the other side of that blanket?
Yes, it is.
This time, you ought to move into evidence, States Exhibit DX.
What says the defense? Be received in evidence as states numbered.
And may I publish?
May.
Did that blanket have some plant material growing in it?
Yes.
And did you have that photographed as well to document the level of plant activity in the blanket?
Yes, I did.
And unpublished to the jury, and if I may have DZ. Is that a photograph representing the amount of plant and root activity actually growing into the blanket?
Yes, it is.
State would move into evidence, States Exhibit DZ.
What says the defense?
DZ.
Be received in evidence as states numbered.
May I publish?
You may publish.
So just tell us what we're looking at here.
This is a close-up of the edge of the blanket, the one with the Winnie the Pooh with Piglet. And it shows vegetative material, roots growing on top of and through the blanket.
Thank you. We could go to E, show the witness EB, please. EB. Do you recognize this as an additional photograph of other areas of root growth in the blanket?
Yes.
Right. This time moved to evidence, State's Exhibit EB.
What says the defense? Be received in evidence, the state's numbered.
Look, for the record, that's ED. I apologize. I said EB. I meant ED. Okay. And may we publish?
You may publish.
Now, if we could have EB as in boy. You recognize this as another photograph of the root material.
Yes.
State removed evidence, State's Exhibit EB.
What says the defense? Be received in evidence, the state's numbered.
And publish, please.
You may.
Again, we're looking at more root material in that blanket.
That is correct.
Unpublished to the jury. Unpublish. Could I have State's Exhibit EE? Do you recognize EE?
Yes, I do.
This is a photograph of more root material growing into the blanket. Is that
That's the
correct?
same blanket with showing root material growing into it.
State removed evidence, State's Exhibit EE.
Be received in evidence, the state's numbered.
May I publish?
You may publish.
Was there also root material growing in the bag, that is the black plastic bag that was found with the remains?
There are two black plastic bags, and root material is growing through the holes in both those bags.
Let me show you, if we can show the witness EI. Does this photograph demonstrate the root material growing actually through the holes in the black plastic bag?
Yes.
This time, State removed evidence, State's Exhibit EI.
Be received in evidence, the state's numbered.
May I publish?
You may publish.
Was there also a canvas laundry bag that was also found with the remains that you saw?
Yes, there was.
And were there roots growing within that item as well?
The canvas laundry bag was canvas on the outside and some type of kind of shiny vinyl type material on the inside, and it appears that the roots were just growing on top of and intricately applied to the canvas part of that bag.
If we may show the witness EN. And do you recognize that as a representative photograph showing the roots growing into the canvas bag?
Yes.
This time I'd move into evidence, State's Exhibit EN.
Be received, the state's numbered.
May I publish?
You may publish.
Would it be fair to say that plant roots were growing in and around virtually everything that was retrieved from this scene that is the immediate area of the skull?
No, I don't think we saw any roots in the shorts.
Okay.
There were certainly roots in bones, but that was further out. Roots through the bag, and then the shirt was completely disintegrated, so it's difficult to say. But certainly the blanket, the 2 plastic bags, and the canvas bag.
And you said the shirt was disintegrated. All that was left was the lettering and a collar?
The lettering and the stitching,
And the stitching.
along the hems, and with the tag.
In order to assist, and I'll just unpublish that, in order to assist in identifying the victim in this case, well, at the time that the bones were first found, how did you go about trying to identify who this child was?
Well, we thought the best identification was going to be through DNA. It's difficult to identify a child because oftentimes we'll use teeth or a dental comparison that was be difficult with this child because she's so young. And so we were hoping that we were going to get nuclear DNA, and then we knew that there would probably be at least mitochondrial DNA. So we thought the best way to go would be with the DNA.
And did your office send a bone off to the FBI laboratory for purposes of DNA identification?
Yes, we did.
Let me show the witness state's exhibit EO for identification. Do you recognize this as a photograph of the bone upon its return from the DNA evaluation?
Yes.
Right. This time, the auditor state would move into evidence state's exhibit EO.
What says the defense? Be received in evidence the state's numbered.
Yeah, publish. Doctor, the portion that's missing from this bone, is that a procedure you're familiar with in determining DNA identification from bone?
Yes, they have to remove a piece of the bone to test, so they removed a piece of that right tibia.
Now, did you receive results from the FBI DNA laboratory as to the identification of the remains?
Yes.
And did that laboratory identify the remains as that is Caylee Marie Anthony?
Yes, they did.
Now, as a medical examiner, is it your job to determine 2 things, one called cause of death and one called manner of death?
Yes, it's the fundamental, it's fundamental to my job, and that's basically why we exist as an office.
Is manner of death determination a purely medical or scientific determination?
Yes, the cause?
Manner of death.
The manner of death, it's based on scientific principles and ultimately gathering all the information you can about a case, all the circumstances of the case, all the history of the case, any medical history, knowing what the body showed, knowing all your ancillary tests. It's to take all of those things into consideration and any type of scientific information and to come up with an opinion.
Counsel, I don't need to go. Okay, ladies and gentlemen of the jury, we're going to recess now for lunch. I'm going to ask you not to discuss this case among yourselves nor with anyone else. Any additional instructions on behalf of the state or the defense? Okay, we'll be in recess to 1:30. Okay, state recognized the presence of jury. Yes, sir. And the defense. Yes, sir. Members of the jury, did you heed all of my previous admonitions during the noontime lunch hour? Okay, Mr. Ashton, you may continue.
Thank you. Good afternoon, Dr. Garavaglia.
Good afternoon.
Let's start off by getting through a few housekeeping matters. I want to approach. Thank you. Let me show you some items that are marked for identification. First is State's Exhibit KL. You recognize that by your office's label as a bag that should contain the laundry bag that was found in evidence in this case.
Yes.
This time you take remove into evidence State's Exhibit KL.
What says the defense? It will be received in evidence as states numbered.
264.
Let me show you what's been marked in evidence, State's Exhibit for identification KU, and ask you if you recognize that by markings as the bag that should contain the baby blanket photograph we saw earlier.
Yes.
This time, Your Honor, the State would move into evidence State's Exhibit KU for identification.
It will be received in evidence as states numbered.
265.
Next would be State's Exhibit KM. You recognize this as, by the markings of your office, as the container that should contain the body bag with vegetation that was brought with the items.
Yes, I do.
This time, Your Honor, moving down to State's Exhibit KM for identification.
It will be received in evidence.
66.
Show you State's Exhibit KK for identification. Do you recognize that by the markings as the bag that should contain the tied black plastic bag that was brought in with the remains?
Yes, I do.
This time, Your Honor, State would move into evidence State's Exhibit KK.
It will be received as states numbered.
267.
Show you State's Exhibit KO for identification. Do you recognize that by the markings as the bag that should contain the untied plastic bag that was found with the remains?
Yes.
This time, Your Honor, State will move to evidence State's Exhibit KO.
It will be received in evidence as states numbered.
268.
Let me show you what's been marked. State's Exhibit for identification KR, and ask you by the markings, that's the bag that should contain the shorts that we looked at in the photograph.
The shorts.
The
I
shorts.
didn't see the shorts in the photograph, I don't believe,
Oh.
but
The
those
shorts
are
that were
the
in the
shorts.
photographs. Let me stop. Did you review photographs of items that were taken and examined by Dr. Botts?
No, I examined those.
Those, okay, and they should be in there.
Yes.
Okay, thank you. State will move down to State's Exhibit KR.
Be received in evidence as states numbered.
269.
Let me show you State's Exhibit KT and ask you if by the markings that should be the bag containing the clothing, the letters, and the stitching.
Yes,
And those are things that were brought in with the body, is that correct?
that is correct.
State will move into evidence State's Exhibit KT.
What says the defense? It will be received in evidence as states numbered.
270.
Now let me show you State's Exhibit KS. If I may approach counsel just a moment.
Right.
I believe by agreement of counsel, rather than have the doctor open this bag to see her markings, that it is agreed that this is the hair mat that was taken into evidence.
That's correct, Your Honor. I have no objection to reading it.
Okay. It'll be received as states number
271.
Right, that's all it is. All right. Dr. Neller, we've got the housekeeping out of the way. When we broke, we were discussing the concepts of cause and manner of death, and I believe you were explaining to the jury what manner of death means. Could you explain that, please?
The manner of death.
Manner of death.
The manner is the classification of death based on all of the information that is available to us, both scientific information, both scene information, both historic information, anything that will help us classify that death as to accident, natural, homicide, suicide, or undetermined.
And in assessing all that thing, the medical evidence, the scientific evidence, and the scene evidence, do you bring to bear your experience in forensic pathology?
Absolutely.
In this particular case, based upon everything that you have seen, the photographs, the skeleton itself, do you have an opinion as to the manner of death in this case?
Yes.
What is that opinion?
Homicide.
What do you base that on?
It's based on three main items. First, we know from observational studies, from experience, that it is a red flag that when a child is not reported immediately to authorities, either with an injury, that's something we look for foul play. This child, from history, was not reported for a long time. The other thing that makes it a homicide is that the body was hidden. A child's body is thrown out, hidden in a field. We know that is one of the things we look for when we are looking for a homicide. Also, it's often found that these bodies are in, not always, but closed containers, a suitcase or a plastic bag like this child was. That, again, is from our experience from observational systematic studies, a red flag for homicide. And the last, besides the delay, besides the being found in a field decomposed, would be the duct tape somewhere located on the lower half of this face. There is no child that should have duct tape on its face when it dies. There is no reason to put duct tape on the face after they die. Based on our experience, we've seen that in cases of homicide.
Now, how does the concept of cause of death differ from the concept of manner of death?
Well, the cause of death is the injury or the disease that initiates the chain of events that ultimately results in the child dying or the person dying. So the cause is the specific injury or disease that ultimately causes the death.
In this case, based on the skeletal condition of the remains, can you render a medical conclusion on the cause of death?
The cause of death What I put was homicide of undetermined means. I believe we can reliably say it's a homicide, but I don't know the means for which that homicide occurred.
Were there any objects found with the body that would have been capable of causing death?
Well, the only possible objects with the body, although I don't know if they cause death, and I'm not even speculating whether they cause death, would be duct tape. If that duct tape was over the mouth and nose, that's a possibility. Suffocation with a plastic bag would have been the only other thing I would have seen there.
Right. You are aware, are you not, of the evidence of chloroform being found during certain portions of the investigation of this case?
I was made aware of that, yes.
Could a child exposed to a sufficient amount of chloroform die as a result?
Absolutely.
But at this point, based upon the medical evidence, can you tell what caused her death?
No, I believe we have enough evidence, and I believe it's scientifically defensible to say it's a homicide, but I do not believe we have enough scientific information to say the means of how that homicide occurred.
Now, are there certain things that you can exclude? In other words, was there any trauma to the body that would
Well, the
connote-
trauma is very, their body is very decomposed. All I have is bone. So unless that trauma hurt the bones, I can't say. There's certainly, I've had other cases where there's been blunt trauma to the abdomen, and I can't say from the skeleton. So I can't rule out really any trauma, because sometimes even a gunshot wound would go through, and not touch the bone. So it's very difficult when the body is that decomposed to say why they died.
Now, in this case, was there any injury to the bones that would indicate trauma involving the bone?
There is no ante-mortem injury to the bones that would indicate the cause.
And were you made aware of any illnesses that the child suffered that could have caused death, anything of that
I
sort?
specifically asked for any history of illness or problems with this child, and I was told there were none.
No further questions. Thank you, Doctor.
Cross-examination?
How you doing?
Hello.
You okay?
I'm okay.
All right. Now, Dr. Garavallo, you live in the Orlando area. Don't tell me where, but in the Orlando area.
Yes, yes, in the area.
Okay. And for the period of time of about 4 months prior to these remains being found, you were aware of all of the media attention surrounding this case, weren't you?
I was aware that this was a big case. I do not watch the news, and I listen to NPR, so I don't think I was as aware as most people.
Certainly, if you were wise enough to not necessarily rely on the news, you were aware that there was, in fact, a circus-like atmosphere around the Anthony home. Yes?
I don't know that.
Well, you knew it was, a lot of speculation and a lot of news about this case for months. Yes?
I did know that there was a lot of speculation about this case.
And you knew that if, unfortunately, remains were found of this child, that your office would be most likely involved.
No, I was hoping it was Lake County,
You were hoping it was Lake County, push it off to the west. Okay.
different jurisdiction.
Or so anywhere other than the 9th.
That's what I would have liked.
But in fact, you were called and you came back from wherever other business you were on to handle this case.
That's true.
And amongst the various things that you had known prior was news or references, as Mr. Ashton just referred to, regarding the potential of chloroform being involved in this case.
I was told that by investigations at the time we got the body.
You weren't told that the chloroform related to decomposition, but just that there was chloroform involved.
That there was a question of chloroform.
So you then reasoned that perhaps chloroform may have been used, in fact, to contribute to the cause of death of this child.
I think that would be one of the possibilities that we would have to examine.
So one of the things that you did in order to examine that possibility was to bring in an expert. Yes?
I brought in a toxicologist that I knew had dealt with toxicology of bones, which is,
Tough.
not a common thing.
And that toxicologist was a PhD, Dr. Bruce Goldberger from the University of Florida.
It was.
And you sent to him a piece of bone that had been resected from the humerus, was it?
The femur,
Pardon?
the left femur.
Left femur. We had a picture of it a while ago.
No, that was the tibia taken for the DNA. The
Well,
picture I saw.
Which part was sent to Dr. Goldberger so he could test for the presence of chloroform?
The piece of the left femur.
And as a toxicologist, the specific request was to look for chloroform and other what you call volatile chemicals. Is that right?
That is correct.
Meaning you were looking for chloroform and some form of poison.
Volatiles would have been alcohol, isopropanol.
Any kind of chemical that might have contributed to the cause of this child's death.
Yes.
And Dr. Goldberger, pursuant to your direction, submitted these samples to a myriad of toxicological examination tests, didn't he?
Not really a myriad. He only did checked for volatiles and several other tests. It was very limited what he can do with bone. But
Whatever tests were available that could be done, were done.
he tried.
And when they were done, the results were negative as to each and every one.
That is correct.
Now, in connection with this whole process, were you present when Dr. Werner Spitz came as a defense expert to want to observe the process?
Can we approach?
You may continue.
I may not be exactly verbatim, but I asked you if Dr. Werner Spitz came down to observe or participate in the autopsy.
Did he? No.
No? Were you aware of him coming down to want to watch your work?
Hearsay. Question of counsel.
Overruled.
I was informed by my office manager that Mr. Jose Baez had requested.
Objection, Your Honor. I don't believe that's what the court indicated counsel could ask.
He's already allowed me to ask the question.
Well,
She's just answering
Judge,
it.
we got
Overruled. Go ahead and finish asking the question, Doctor.
Go ahead, Nancy.
Go ahead.
I was informed by my office manager there was a request by Jose Baez to bring an outside person in to watch the autopsy, and our policy in the autopsy is that we have a statutory duty to come up with the cause and manner of death. We would preserve everything possible then and make that available to him when we are finished.
Okay. And you told Mr. Ashton that in your determination of the manner of death, you consider all kinds of circumstances.
Yes, I do.
And in doing that, in this case, are you aware of whether or not Dr. Spitz, in fact, did a second autopsy?
objection, hearsay.
It's a statement.
Okay. Now, I want to go back just briefly to Dr. Goldberger. I've been reminded that he's a medical doctor, isn't he?
No, he is not.
He's not?
Dr. Goldberger? He's a PhD.
Is he also a medical doctor?
Not to my knowledge.
All right. Well, what things do you know that he tested besides that piece of bone?
Let's see, for volatiles, he tested bone, The scrapings I took from the inside of the bone, the hair and soil that kind of fell out of the hair. And that was for volatiles. And then he tested the bone, and then the scrapings from the bone marrow, and washings we did from the cranial cavity. And he tested that by gas chromatograph for prescription drugs, illicit drugs. And then he tested specifically for alprazolam in the bone, the scrapings of the bone cavity, the washings of the cranial cavity were all then specifically tested for alprazolam.
And alprazolam, what's a more common name?
It's a benzodiazepam, also known as Xanax.
Xanax.
Yes,
So he tested for all those things and all the results were negative.
that is correct.
And speaking of the cranial wash you did not cut open the cranium, did you?
No, absolutely not.
Now, you told Mr. Ashton also that there was no trauma found in your examination, correct?
No antemortem trauma, meaning prior to death. We found some postmortem trauma from animals chewing on bones, and
You found the postmortem trauma, the anthropologist confirmed to you that there was indication of animal activity, right?
oh, you could say that.
Okay.
That was part of my examination.
But anything that happened before, there's no evidence of any form of trauma before when this child was alive.
On the bones, there was no evidence of trauma.
And in your exploring all the world of circumstances about this, you didn't find about any trauma either, did you?
No, I did not.
So if I understand your testimony, you, the long and short of it is, are confirming that despite the investigations, the toxicology, the anthropologists, all of these things, there is no scientific or medical evidence to establish the cause of this child's death. Is that correct?
The means of the homicide could not be determined.
And you determined to call it a homicide as opposed to an accident or indeterminate.
The circumstances of death and did not fit anything but a homicide.
The circumstances.
That's the way the body was found.
Okay.
And not
I know
reporting
that.
the body.
And also what Detective Melich told you.
I'm not, what part did Dr. Melich tell me? The part that the body wasn't reported for 31 days was what
You
he told me.
learned these things from Yuri Melich, an investigator.
That's our standard,
some of the
of course,
things-
of business.
Some of the things you learned from the media.
From you?
Media
Oh, media. No, nothing from media would have been entered into my decision.
didn't enter your mind.
Well, I can't take anything that the media would say into a decision as grave as this.
So the bottom line is when you say, and you place the label homicide, the indeterminate means, you're saying that circumstantial evidence to you says that it probably was a homicide.
Not probably. I think that is the only logical conclusion based scientifically on some of the scientific information we have, based on observational information we have about homicides and children dying.
What is the scientific information, the circumstance?
Well, we know, and of course, observational, systematic observational studies are part of science. That's a big part of forensic. It's a big part of how we know our world. We look at all the accidental drownings, for instance, in my jurisdiction. We systematically went through those. 100% EMS is called immediately when the child is found.
Well, that has nothing to do with
Oh,
this case, does it, Doctor?
Oh, no.
Objection, argumentative.
Sustain.
Okay.
It, oh,
Go ahead, Doctor.
It absolutely has something to do with this case. Every death I investigate has to put into the circumstances of death. You can never, ever determine a manner of death, except in very rare instances, just on examining the body. And so it always has to. So we need to know how usually deaths occur. So we have to know, and there's scientific studies in peer-reviewed literature
and
about
I'm
some of the
gonna object to
red
the bolstering
flags
she's trying to do
for
right now.
homicide.
Objection to the bolstering. She's now talking about studies. We don't have them.
Overruled.
So by my experience and by what is known about the way homicides occur, I felt that the preponderance of evidence and that there was no other logical conclusion could be found by not reporting a child for 30, who has a legal, moral, and ethical obligation to care for a child, not reporting that child missing. The fact that it's tossed in a field to rot in bags is a clear indication that the body was trying to be hidden. Those are, even it being put in a bag is a very big red flag for homicide and never seen in an accidental death of a child. And the fact that there's duct tape anywhere attached to that child's face is, to me, indication of a homicide.
Okay, now let's back up. What about your circumstantial observations and deductions is scientific, ma'am?
The fact that we know 100% of the time that accidental deaths are reported unless there is a good reason not to be. We know that there is no reason not to report. In fact, if you do not report an injury to authorities, you are risking that child's life. So we know that's partly behavioral science. And we know in all of the cases that come through our morgue that accidents are 100%, particularly on children, are reported unless there's a good reason not to.
So you're trying to tell this jury 100% that there's no way that this death could have been accidental?
No, I said 100% of the time, let's say on a systematic review of drownings, it's one of the more common accidents, 100% of the time when the person finds the child, they call 911 because there is a chance that that child might live. They need to report that and give them a chance.
And what if a person finds an obviously drowned body, is so obviously deceased? What then? Is there some scientific thing to your conclusion about their morality?
No, but I'm looking at the behavior as a systematic observational information that shows that no matter how stiff that body is, they always call 911 on the hopes that that child could be saved. I'm looking at observational data on that kind of death. That's what we use.
So you're saying then, by your determination, the circumstantial evidence is that's what causes you to conclude it must have been a homicide because you can't explain it any other way.
I explained to you the red flags that we know in forensics
First of all, Doctor,
based on behavioral science.
You need to answer my question.
I don't understand.
Your Honor?
Objection to counsel.
Just a second, folks. Mr. Ashton, objection.
Objection to counsel instructing the witness. That's
To-
the court.
I'd ask the court to instruct her to answer my question. The question I asked her to call for a yes or no answer.
Please repeat the question.
Objection sustained. Mr. Basin, the question did not call for a yes, no answer. It was sort of open-ended. So if you want a yes or no answer,
I'm sorry, I didn't hear the last part.
okay. All right. Doctor, did you finish answering the question?
I don't even know what the question was.
See?
Okay, then let's have a new question.
I don't even remember. The bottom line is, let's just take it and make it simple. Cause of death, you don't know. Manner of death, you say based on the circumstantial evidence, you conclude that it was a homicide for the reasons you told us.
I felt that the manner of death, although the cause of death is homicide by undetermined means, I felt the Means were unable to be substantiated scientifically. I felt the manner of death was defensible scientifically based on systematic observational studies.
Okay. Of observational studies of other things, other cases.
Of homicide, how homicides occur, how accidents occur, how natural deaths occur, yes.
Other cases.
Other cases.
Okay. Now, by the way, if these remains had been found 4 or 5 months before, would you have had better chance at scientific evidence?
Absolutely.
And incidentally, you said something about duct tape. Isn't it true from what you observed and saw, if there was any duct tape, it was only in the vicinity of the lower mandible?
That's correct.
I have just a minute, Your Honor.
You may.
Thank you very much, Doctor. I have no further questions.
Any redirect? Sir. You may proceed.
Doctor, Mr. Mason asked you about your knowledge of the defense's desire to do a second autopsy of the body.
Yes.
Did you attempt to keep the body in exactly the same condition it was when you received it?
Yes, we did, except for what we had to take for DNA and for the possible toxicologic testing.
You left the roots in the bones just as you found them?
Yes.
And
In
left
fact,
the-
we packaged it nicely so they could keep the anatomic groups together.
And you left the skull intact just as you had found it?
Yes, that's normal procedure for an anthropologic exam, is to keep that intact.
Now, the absence of positive results for chloroform or other substances, does that, as a matter medically, exclude the acute use of those substances at or near the time of death?
Right. We would not expect to find any of those things positive in a bones. That was a long shot trying to check for those, but I thought we would be amiss not to at least try. We would not expect any of those to be positive in a set of bones, even if they were positive at the time of death, even if it was present.
Taking, for the purposes of my question, for the following hypothetical, the following facts. Assume that Caylee Anthony died and was discarded on or about June 16th of 2008, approximately 6 months before the body was found.
Yes.
At the stage that Mr. Mason was asking you about 4 months earlier, which would have been August, so the body's been out for 2 months. What would be the body's condition after 2 months?
Oh, well, it's probably be skeletonized. Certainly would be skeletonized by then.
So if the body had been found in, let's see, August, would you expect that it would have been skeletonized with very little soft
Yes.
tissue?
Yes, I would expect it to be skeletonized.
Would you expect the internal organs to be completely?
Completely gone.
Thank you. No further questions.
Recross as to those issues.
And you're a forensic pathologist, a forensic anthropologist, is that correct?
Yes, sir.
Where do you work?
I'm an associate professor at the University of Florida and director of the C.A. Pound Human Identification Laboratory.
Kind of slow it down, Doctor, so with this technical stuff, it makes it difficult for court reporters.
Yes, sir.
Okay.
I am associate professor of anthropology at the University of Florida and director of the C.A. Pound, which is a man's name, C. Addison Pound Human Identification Laboratory.
All right. We'll skip your qualifications and jump right into the issue.
Okay.
Were you involved in the original investigation of this case, and did you work with Dr. Schultz in preparing his report and analysis in this case?
Yes, sir.
And did you actually participate in examining the skull and other bones involved in this case?
I did.
Now, getting directly to the point, at some point discussions began about the issue of the duct tape and establishing whether it could be the weapon that caused death. Correct.
That's correct.
Now, how was this video superimposition created?
It was created by taking photographs that we had taken during our examination of the decedent's skull, and also photographs taken of the tape by the Federal Bureau of Investigation, and a photograph that was found on the internet that was appropriate in terms of the orientation of the child's face to the photograph that we had of the skull.
All right. Now, why is it necessary to use a picture of the skull and the face in order to do this?
Both the photographs of the skull and the photograph of the tape have photographic scales in there, and those scales are used then to make sure that the size of each of those images are exactly comparable. The face has no scale in it. So if we're going to superimpose the tape onto the soft tissue of the face, there's no way to do that unless we first match the face to the skull in terms of sizing and aligning that, and then by using the scale in the tape, we're able then to superimpose that onto the soft tissue.
So would it be fair to say that by using the skull, you're able to make sure that the face is in one-to-one with the tape?
I had to use the skull, yes, sir.
Had to use the skull. Now, while you can give estimates, let me rephrase that. Is it possible without this superimposition for you to precisely determine the distance between the end of Caylee's nose and the bottom of her chin?
It is. Using the scale in the photograph, we can do that.
Without that, though, would you be able to?
No.
Are there certain rough estimates that you can make based upon research about the average distances in a child of that size, and et cetera, of that area?
There are data out there, previous studies, studies called anthropometry, which is the measurement of living people for children. And one particular study in 1977 done by the University of Michigan and the Highway Safety Division has some measurements, but not the measurements that we needed from the landmarks that are in question.
So to your knowledge, would there be any other way to demonstrate that the duct tape could cover both her nose and mouth other than this process?
There's not. Other than using, again, anthropometric measurements, those are populational data. Those populational data take into account the variation that we see in humans. When you are applying populational data to a single individual, you're basically using populational means and applying them to a single person. If you can do your measurements and do your work on the individual in question, then it's a more elegant approach to that, and really the only way in this case to do it.
Unless the council has, that's all the questions I have for the proffer.
Mr. Byers?
Sir, Mr. Ashton talked about discussions about the duct tape being the murder weapon, correct? You recall that?
I don't recall direct questions from Mr. Ashton about the duct tape being the murder weapon.
The very first question just now that he brought up were these discussions.
Discussions between me and Dr. Garavaglia and Dr. Schultz, yes, because the tape was seen.
And Mr. Ashton also had these discussions with you, did he not?
I don't remember him talking about that being the murder question or the murder weapon. I remember him asking, and the question being whether or not it's possible that that tape could cover both the nasal and oral airway.
Okay. And when did that discussion take place?
Early on, during probably the first day that I was there, we started talking about the possibility of whether that tape could have covered both airways.
And this is the first day you were there, you were having these discussions with Mr. Ashton?
No, I had not met Mr. Ashton at that point. No, that was just with Dr. Garavaglia and Dr. Schultz.
And later
Dr.
on
Utz
this happened?
well. Later on, yeah, I think it was I that suggested that we do the superimposition to demonstrate the possibility of that tape covering both airways.
And who made this suggestion to you?
I think I made the suggestion, I think,
Okay. To who?
to Mr. Ashton.
Okay. So you suggested it to Mr. Ashton while considering the prosecution of this case?
Excuse me?
While considering the prosecution of this case?
Yes.
Okay. And you weren't present when the duct tape was removed from the skull, were you, sir?
No.
Okay. So you never saw where this duct tape was positioned near the hair or anything like that other than a photograph?
That's true.
Okay. And of course, the photograph that you saw are the ones that are admitted in evidence, correct?
Yes, sir.
And they're the ones that are attached to her skull. I mean, her hair mat, correct?
Yes, sir.
Okay, not to her skull.
Not to her skull.
Right. Now, the hair mat is underneath her skull, is it not?
Object to the relevance of this to the proper, to the 403 issue.
I thought we were not going to have objections.
Well, let's get to the point. I don't want you to do your entire cross-examination. I just we're here to determine a 403 issue.
Yes, sir. I'm tying it all together here. Judge,
Okay,
if I
let's
can have
get
just
there.
a moment. The hair mat was underneath Caylee's skull, correct?
It was nestled at the base of the skull, correct?
Okay. And normally hair is not on the bottom of a skull. It's usually on top.
Decomposed skulls, yes, the hair can slump and
But I'm
find
talking
out.
about when a person's alive,
Yes,
right? Just like in the photograph, she's alive, her hair's on top.
correct.
Okay. And there's no scale on her face in that photograph, is there?
No,
Okay. And you don't even know how old Caylee was when that photograph was taken.
that's true.
And this is just some photograph you took off the internet.
Correct.
Okay. So to fairly and accurately have this depiction, you would of course need to know how large the child is, correct?
No, I would have to have knowledge of the landmarks of the face and how they fit and the relationship of the soft tissue to the skull to adequately scale that.
But children grow fairly rapidly, don't they?
They do.
Okay. And she could have been much older or much larger in that photo at the time of her death than was in that photograph, correct?
The photograph to me looked like it had been taken fairly recently prior to her disappearance.
It just looked that way to you, but
Correct.
you don't know for
Correct.
for
It's
certain.
not an infant's photograph, in other words. Yeah.
Doctor, what is the purpose of this demonstration?
Purpose of the demonstration is to illustrate that it is possible that the width of the tape would cover both the child's nose and the oral, the mouth.
A skull was utilized. Explain to me the necessity for the skull, doctor.
Okay. We took the photograph of the skull and a frontal view of the skull with a scale, a photographic scale. We also have a photograph of the skull, or the tape taken by the FBI, that also has a scale in that. By using both the skull and the tape and overlaying those images with 50% opacity in this software program, you basically can take those two and you can make those scales the same size so that you know that the size of the skull relative to the size of the tape is real, that those match. There's no scale in the photograph, but I can scale the face to the skull by using anatomical landmarks. So once we have the orientation of the photograph and we have that photograph scaled to the skull, now we're able to move from the scale in the skull to the scale in the tape. And if we're going to, yes ma'am, we're able to, once we have the skull scaled to the photograph, then we're able then to superimpose the tape, which has also been scaled to the skull, over the image with the soft tissue.
Now, doctor, the skull that was used was the actual photograph of the skull that you received from the medical examiner's office?
Yes, sir.
Okay. Will this animation aid you in explaining your testimony to the jury?
It will, in terms of whether or not it's possible, that single question, is it possible that that tape covered both the nose and the mouth? I think it illustrates that it is, in fact, possible that it did.
Without that animation, would you be able to do that, sir?
I would be able to testify based on my knowledge of anthropometry and the literature of that. It is, in fact, possible that it did without using the animation, yes.
What are the advantages of or disadvantages, sir, of not utilizing the animation?
The disadvantage is it takes that illustration and the science out of my explanation to the jury. In other words, they'd have to trust that I am familiar with the data. And when I tell them that, the tape, in fact, the width of the tape, which is 1.75 centimeters, and the anthropometric measurements between those landmarks, that in fact that would cover both of those.
Okay.
So.
Thank you. Anything else?
Just one small thing. Based upon looking at the skull and looking at the photograph, is it your opinion as a forensic anthropologist that they are close in time? In other words, there hasn't been significant growth in between the photograph and the skull picture?
Yes.
All right. I have no further questions. Would you like him to step down or just?
The witness can stand up. And Mr. Baez, the case that you want the court to take notice of is Pierce versus State.
Yes, sir.
7/18/7/803, a 1997 decision by the 4th District Court of Appeals.
Yes, as well as, I'm sorry, I was just handed another one that appears to be on point, and that is Camporamore versus Brandon Pest Control at 721 Southern 2nd, 333.
Okay. We will be in recess to about 3:15. I need to digest these cases. Okay. False imprisonment over in Volusia County. The court said the following in its opinion. Relevant evidence is defined as evidence tending to prove or disprove a material fact. But the relevant evidence is inadmissible if the probative value is substantially outweighed by dangers of unfair prejudice, confusion of issues, misleading the jury, a needless presentation of cumulative evidence. The proper application of Section 94.3 requires a balancing test by the trial judge. Only when the unfair prejudice substantially outweighs the probative value of the evidence must the evidence be excluded. Unfair prejudice has been described as an undue tendency to suggest decisions on an improper basis, commonly, though not necessarily, an emotional one. This rule of exclusion is directed at evidence which inflames the jury or appeals improperly to the jury's emotions. In performing the balancing test to determine if the unfair prejudice outweighs the probative value of the evidence, the trial court should consider the need for the evidence, the tendency of the evidence to suggest an emotional basis for the verdict, the chain of inferences from the evidence necessary to establish the material fact, and the effectiveness of a limiting instruction. The trial court is obligated to exclude evidence in which unfair prejudice outweighs the probative value in order to avoid the danger that a jury will convict a defendant based upon reasons other than evidence establishing guilt. The evidence which is being sought to be introduced is basically a superimposed photograph of the victim, the skull dealing with the placement of duct tape. The defense cites for the proposition that this evidence should be excluded 2 cases. Pierce versus State found that 718, 7 2nd, 806, a 1997 decision of the 4th District Court of Appeals. The Pierce case basically dealt with a computer-generated animation illustrating the lead traffic homicide investigators' reconstruction of an accident was published to the jury as demonstrative evidence. The court in that case found that this was a case of first impression dealing with computer-generated animations, did its 403 analysis and concluded that the videotape demonstration demonstrated no blood, replicated no sounds, and found that through its 403 analysis that they found no error in admitting, no error by the trial court admitting the use of the computer-generated animation to the jury. This case here mainly dealt with the first-time utilization of computer-animated generation and was not helpful to the court in its analysis of the 403. The next case cited by the defense is found at 721 7 2nd 333. The Brandon Pest Control case, a 1998 decision of the 2nd District Court of Appeals. This case involved a videotape that was of approximately 15 minutes duration that was taken at the residence in question. This particular tape demonstrated extermination equipment and pointed out its utilization, the drilling of holes and injecting various chemicals throughout the house. It also had some computer-produced animations throughout, and the court, along with some narrations. The court concluded that the narrations contained throughout and that this tape was basically a self-serving promotional tape. Thus, the court concluded that it should not have been introduced in evidence in this particular case. Although this opinion is not very long, it does not go through a 403 analysis. In looking at the factors talked about in McDuffie, the court will make the following observation. One, the court needs to consider the need for the evidence. In this particular case, there has been made an issue by cross-examination and direct examination dealing with the placement of duct tape upon the victim, Caylee Marie Anthony, and the location of this duct tape. The court will also note that there is a nondescript picture of Caylee Marie Anthony, and there's also the utilization of the skull of Caylee Marie Anthony, which the jury over the last 2 days has seen several pictures of that particular skull. The skull does not expose any blood, gore, or anything of that particular nature. The doctor has indicated that this will illustrate his particular testimony and that it would aid and assist him in his testimony, even though he said he could do without it, but he said it would be helpful. Does the evidence suggest an emotional basis for a verdict? Unfortunately, in homicide cases, evidence tends to be not so nice. But this particular piece of evidence, a live photograph of the victim superimposed with the skull, does not have a tendency to suggest an emotional basis for a verdict. Is the evidence necessary to establish a material fact? Both sides have debated the relevancy of this duct tape and the placement of this duct tape. Thus, it is highly relevant to the determination for the trial of fact to conclude, based upon all evidence, whether or not this duct tape was placed in a certain position. That is something for the trial of fact and the trial of fact to determine. Therefore, based upon what has been presented to this court, the court will permit the witness to testify. Last but not least, pursuant to if requested by the defense, pursuant to Pierce, I will give the following limiting instruction. This evidence is used only to illustrate the expert's opinion. Like all witnesses, the experts, like all witnesses, experts are like all witnesses with one exception. The law permits an expert to give his or her opinion. However, an expert's opinion is only reliable when given on a subject about which you believe him or her to be an expert. Like other witnesses, you may believe or disbelieve all or any part of the expert's testimony. Is the defense requesting that limited instruction to be given prior to the testimony of the expert?
Yes, but we still do not waive our previous motion and objections, Judge.
Okay. As to the other issues raised at the sidebar, we did not answer the question whether or not the state had indicated that they were going to utilize it at trial, but it had been disclosed to the defense before. Therefore, the court did a what I call Richardson analysis, since it violated my order to determine what prejudice by not telling them that they were going to utilize it, but it had been disclosed and the witness had had his deposition taken. With that, are there any other matters we need to take up prior to the jury returning? Any other matters on behalf of the state of Florida? Defense, Mr. Baez?
Yes, sir. The only thing that I would caution, or I would advise the court as to what may also occur with Dr. Warren's testimony, is that we have cumulative testimony. He co-authored a report with Dr. Schultz. I would just, I guess, bring notice to the court that that may occur, and certainly that's something we would like to avoid and object to.
If there are any issues as to Dr. Schultz's testimony, the defense is not challenging that might be true, but my understanding is the defense is not stipulating to the accuracy of anything that Dr. Schultz said, so I would submit that additional testimony on the same issues would not be cumulative, but would be relevant.
Mr. Byers?
Well, in his deposition, he clearly states that he would defer to Dr. Schultz on these matters. Why not bring in a third forensic anthropologist to say the same thing? And that's the problem here. If he's going to testify to something different, certainly would not have any objections to that. But to improperly bolster Dr. Schultz's testimony by putting on more of the same thing, I think that is cumulative. It goes to the very definition.
Can you cite one case that says having two experts testifying on the same topic is cumulative?
I think that falls under the court's discretion, and I just wanted to.
Usually what I do, Mr. Baez, if you have more than two, then you're gonna have to justify to me why you need a third one. Because after two, it gets to be cumulative, in my opinion.
Being our last forensic anthropologist,
Anything else, folks,
not from the state.
from the defense? Okay, let's return.
Can you explain to the jury what the CA Pound Human Identification Laboratory is?
The Pound Lab is named after the gentleman who endowed the laboratory. It is a working forensic anthropology laboratory. We are responsible for consulting with medical examiners in cases in which the decedent has become skeletonized, burned, fragmented, or otherwise unrecognizable.
And how long have you been the director of that laboratory?
About 2.5 years.
Kind of give us, if you would, your educational and work history leading up to your becoming the director of the Pound Human Identification Laboratory.
Okay, I had a prior career as a paramedic for 15 years. I returned back to graduate school in 1991, received my master's and PhDs at the University of Florida, training under William Ross Maples, forensic anthropologist. I did 1 year postdoc after I received my doctorate in the Pound Lab, and was a visiting professor until I was hired onto the faculty on August of 2000 as an assistant professor.
And did you work as an assistant professor at the University of Florida until you became an associate professor and then took over as the head of the laboratory?
That's correct. Since the year 2000 up until I became director, which would have been in January 1st, 2009, I was working in and out of the laboratory, consulting on cases, but also doing teaching and research in the Department of Anthropology.
Have you ever been qualified as an expert to give opinions in the area of forensic anthropology?
I have.
And on how many occasions, if you can approximate?
Probably 16 or 18 times.
And in what type of jurisdictions? Just in the state of Florida, other states, federal?
There's been 2 other states, Alabama and New York, but mostly Florida.
This time, Your Honor, I would submit Dr. Warren as an expert in the area of forensic anthropology.
No objections.
Ladies and gentlemen, the juror, Dr. Warren, will be accepted as an expert witness in the area of forensic anthropology.
Now, do you have I don't know if you call it a specialization or a special interest in forensic anthropology involving children?
My doctoral research was in fetal growth and development, the effect of pathology on linear bones of children, but that was during the fetal period. Any other interest I've had has been involved in determination of age at the time of death, both in juveniles and adults.
Now, did you become involved in the investigation of the death of Caylee Marie Anthony?
I did.
How did you first become involved in this investigation?
I was contacted by Dr. Garavaglia and Dr. John Schultz on December the 15th in 2008 to come down and assist in the analysis of the remains.
And did you travel to the District 9 Medical Examiner's office for that purpose?
Yes, sir.
Now, in addition to examining the remains, did you also examine photographs taken of the remains as they appeared when they were found?
Yes.
I want to direct your attention to one specific area of that. Do you recall, either from the photographs or what you were told, that what the position of the mandible was in reference to the skull when it was first found?
Yes.
Go ahead.
Yes.
All right, what was that position?
The mandible was still articulated at the glenoid fossa or mandibular fossa of the cranium. The mandibular fossa at the TMJ, the jaw joint.
So you say articulated, what does that mean?
It means it was still in place. It was in situ.
If you could slow it down just a little bit.
I'll do
it would be
that.
of great assistance to us.
Yes, thank you. Why is that noteworthy?
Well, that particular joint is a regular type of synovial joint with an articular disc. It's a very lax joint in that joint allows movement of the jaw in two different directions, both as a hinge and also to move anteriorly. There's nothing to hold that jaw in place once the soft tissues decompose. So on surface depositions, on cases in which remains are found on the surface of the ground, it would be very rare to find the jaw still articulated with the rest of the skull.
And in your experience, in cases that you have worked over the length of your career, have you ever had a case in which the jaw, in an above ground deposition, was still in that position in the skull?
Yes.
And what were the circumstances of that case?
These are cases that I worked when I was doing some human rights work in the Balkans, in Bosnia, and I think also probably in Kosovo, in which the decedents had tape over their face.
Other than that circumstance, do you consistently find that the mandible has disarticulated from the skull?
Yes.
And is that your experience, or is that experience, withdraw the question. Now, you're familiar with the photographs of the position of the tape in reference to the mandible and the opening for the nose, the nasal aperture, is that correct?
The photographs, yes, sir.
All right. Now, can you tell from the photographs whether the tape in life would have been over the nose and the mouth?
No.
Why is that?
The tape had moved.
Now, did you attempt to determine whether it was possible that a single piece of duct tape of the type on the body would have been sufficient to cover both the nose and the mouth, even just one piece?
I did.
Overall,
What efforts did you make to determine whether a single piece would have been sufficient to cover both the nose and the mouth?
Two methods. I consulted the literature, the scientific studies that have been done on growing children to try to figure out the distances, the normal distances between various landmarks on a child's face. The best piece of literature I was able to find involved
Proper bolstering.
I believe he's referencing the research he used in order to render his conclusion, not the conclusions of other.
well, Sustain, just tell us what you did, Doctor.
All right, okay.
Without telling us what the literature
I'll
says.
rephrase.
Okay.
Did you research the literature to determine estimate ranges of the distance between the tip of the nose and let me rephrase. Which anatomical features were you interested in for this purpose?
I was interested in the nasal aperture, the very bottom of the nose, and on the skull that's called the nasospinale. So it's a point that we use when we do measurements. So it's basically the very root of the nasal aperture. And I'm also interested in the bottom of the teeth and the oral airway.
All right. And were you able to get estimates based upon Caylee's age of what that might have been?
Estimates, not using those exact landmarks, but in particular one landmark that is from the middle of the eye down to the bottom of the chin.
All right. Now, what was the other method that you used?
I used a method called video superimposition.
And explain to the jury what, pardon me, what has video superimposition been used for in forensic anthropology normally?
It's primarily used to exclude the possibility that the remains in question are those of a particular decedent.
How do you do that if that's your purpose?
You would take the skull that you have of an unknown decedent that is in the laboratory, and you would take a photograph or a video of that skull, and you would take a photograph of the person, the putative decedent, the person that law enforcement or the medical examiner thinks that person may be.
Repeat the last word, I didn't understand it either.
I'm sorry.
Putative,
Excuse me?
your last word that began with a P,
Putative.
Putative. I'm
Putative.
sorry, putative, the suspected decedent.
Go ahead.
If you slow it down, doctor, it'd be very helpful.
Okay, I'm sorry. So you take the skull at that point. You also take the photograph of that individual, and using a comparison method where you are able to superimpose that image on top of the skull using anatomical landmarks, you may be able to make a statement on whether or not it's possible that the photograph is of the person that is the unknown skull that you have.
What type of things are you comparing? You said anatomical landmarks, like what?
You usually would use something like the bottom of the teeth. We also use what we call osteometric points. So there are various points on the skull that we use when we do our metric analyses. So when we measure with calipers, we use certain anatomical landmarks. So it may be the edge of the orbits. It may be what we call, there's a point at the root of the nose that we use, the top of the head and the contours of the skull.
Now, in this case, identification of the skull was not the issue that you were addressing, correct?
Correct.
How did you utilize that process in seeking information as to whether the tape could have covered the nose and mouth?
I use that technique in order to scale the photograph of the skull with a photograph that was provided me by the FBI of the tape. Both of those images had metric scales in them, so by superimposing one image on the other and making those scales the same size, we're able to know that those two images are, in terms of scaling, correct.
So that would help you put the tape over the skull, but how do you then determine how it would have been had the face been there?
Well, we would go back to the original techniques that we've normally used superimposition for. That is to take the photograph of the skull, the photograph of the decedent, and then scale those using those anatomical landmarks.
So you're, in essence, making the photograph of the live person the same size as the one-to-one with the photo of the tape,
Correct.
using the skull as the vehicle to do that.
Exactly.
And in this case, were you able to do that?
I was.
And did you review earlier State's Exhibit QH marked for identification? We showed it earlier here during the
Yes.
break. Okay. And does that fairly and accurately depict the video superposition showing that process?
It does.
And would it help you in explaining what this tells us about the ability of the tape to cover the nose and mouth?
It would.
This time you ought to move it down to State's Exhibit QH, the one file shown to the court, the movie file.
Noting previous objections by the defense, and you renew those at this time, Mr. Baez?
Yes, sir.
It will be received in evidence as states numbered
172.
Is it queued up?
Okay, prior to publishing this, I need to give you the following instructions, ladies and gentlemen of the jury. This evidence is to be used only to illustrate the expert's opinion. Expert witnesses are like other witnesses with one exception. The law permits an expert witness to give his or her opinion. However, an expert's opinion is reliable only when given on a subject about which you believe him to be an expert. Like other witnesses, you may believe or disbelieve all or any part of the expert's testimony. You may proceed.
Oh, yes. Okay, it's published to the jury now. Play it. The video we just saw, we see the outline of the tape being moved up and down on the photograph. What is the reason for that?
To show that we don't know where the tape was, that it could have been higher, could have been over both the nose and the mouth, but it could have been lower than that.
So there is a position demonstrated there where the tape would have been only over the mouth and not occluded the nose.
That's correct.
But based upon that video and your own research, would the single piece of tape, if applied in the position shown on the video, been sufficient to have covered the nose and mouth and made breathing impossible?
Yes.
No further questions.
Cross-examination.
May it please the court, Mr. Ashton. Good afternoon, ladies and gentlemen. Good afternoon, Dr. Warren.
Good afternoon.
Sir, you never saw, you were hired in pretty early in this case, were you not?
I wouldn't use the term hired, I was consulted, yes.
Okay, you were consulted fairly early in this case.
Yes.
But you never saw the duct tape while it was attached to the hair mat.
That's true.
And that's what it was attached to, the hair mat.
Yes, there were strands of hair that were adhering.
Okay. And the photograph that you used to do this, what is it, a flash movie of sorts?
That's a QuickTime movie from a Photoshop program.
And Photoshop's something that you use to design websites and things like that?
It can be used in a lot of different applications. I'm not sure if you can use it for that.
Okay. However, it doesn't give you precise measurements and things like that. That's something that you did based on your experience.
It should give you very precise measurements if you're scaling. I mean, the image is the image, so.
However, the photograph that you have of Caylee, you grabbed that from the internet.
Correct.
And you don't have a scale on that photograph.
Correct.
And in fact, you don't even know how old Caylee was when that photograph was taken.
That's correct.
Okay. And sir, the only reason you've shown this to this jury is because I guess it's to demonstrate that it's possible that this could have occurred.
Correct.
And when we say this could have occurred, I mean it's possible that a piece of duct tape could have covered her mouth and her nose.
Yes.
Okay. And you're not testifying in any way that that's actually what happened.
No, I'm not.
Okay. And when you say it's possible, it's also possible that it was not.
Correct.
In fact, it's a form of speculation, is it not?
It's a form of demonstration to show a possibility, yes.
Which is a form of speculation since you don't know, right?
Right.
Now, sir, you can't testify that this duct tape had anything to do with Caylee's death, can you, sir?
No.
Okay. In fact, you can't even testify or base anything scientific that that tape was associated with Caylee after her death.
Can you
I'll
ask
rephrase
that
the
again,
question.
please?
Sure. You don't know if that duct tape had anything to do with the disposal or the death.
True.
Okay. And in fact, I'm gonna draw a model here, and I'd like to see if you agree with the facts.
Okay.
You understand that Caylee was found on the surface, correct?
Correct.
And that below the surface was the hair mat.
Correct.
Above the surface, I meant, sorry.
Yes.
Correct? Okay. Sorry. And then after that was the mandible.
Yes.
And then above that was the skull.
Correct.
Okay. Now, generally speaking, when a person's alive, their hair is on top of their head.
Correct.
So somehow, actually, I forgot to mention, the duct tape was also found in front, like that, attached to the hair, correct?
Correct. Across the front.
Okay.
These multiple colors, in fact. Can everyone see that okay, or let me pull it closer? Yeah. May I put it closer to the tree? Can everyone see that okay? As I mentioned earlier, sir, the hair is generally up here, correct?
So that I can see it too. Sure. Just slightly, so that I can.
Is that better?
Okay. Yeah. Thank you.
I don't want to exclude any.
No.
Everyone can see that okay? Okay.
I cannot.
Oh, okay. That might help.
Yeah,
How about,
that's
may
good.
the witness stand down, Your Honor?
The witness may stand down. Sir, when you stand down, you're gonna have to face in the direction of the court reporter so she will be able to see and hear you.
Now, sir, as we mentioned, the duct tape was attached to her hair, correct?
That's my understanding from observing the photographs.
Okay. And that's really the only thing, let me rephrase that. It was your understanding too, based on consultation and the evidence at the scene, is that at one time her skull was inside of 3 bags, correct?
Objection. Hearsay, speculation. Who?
Sustained but rephrase the question.
Yes, sir. Based on the evidence that you were given to make your, to form your opinions, it's your understanding that Caylee Marie Anthony's remains at one time were in 3 bags, correct?
That is my understanding, yes.
And it is the understanding that there is a canvas bag. Were you able to see that canvas bag?
Only photographs.
Okay. And that canvas bag had a shape, like a round cylinder shape, correct? Like that as an opening?
The photographs that I saw were not clear in terms of what the opening looked like.
Okay. Were you able to see the handles of the bag?
I don't recall handles.
Okay. Do you recall if that bag, are you able to close that bag?
Again, I've only seen photographs of the bag, so.
So you have no idea as to whether the bag was closable or not?
I do not.
Okay. And you have no idea as to whether this tape was used to wrap Caylee's remains or whether the duct tape was in the anatomical position of which it was found, because of course you did not see the remains as they were decomposing.
Objection.
Correct?
Compound argumentative assumes facts not in evidence.
Sustained, rephrase the question.
Yes, sir. You have no idea the placement of that duct tape.
The duct tape was at least over the mandible and some portion of the maxilla.
Okay, now, but that's because it was attached to the hair, was it not?
I make that statement on the fact that the mandible was found articulated with the skull.
And while we're talking about the skull, there's absolutely no way that the hair would have gotten underneath all of this because the body wouldn't have decomposed in that way. Isn't that true, sir?
Objection assumes facts not in evidence. I could explain more at the bench.
Approach.
Thank you.
Sir, I'm going to show you State's Evidence 218. May I approach the witness?
You may.
No, sir. That's okay.
Thank you.
Now, that's a photograph where you can clearly see the hair mat, correct?
Correct.
And that hair mat was on the floor in the wooded area off Suburban Drive, correct?
The photograph is not a Suburban Drive, and the document speaks for itself. The photograph speaks for itself.
Your Honor, I would object to the speaking objections.
Overruled. Let's continue.
When the skull was found, the hair mat was on the floor, correct?
On the surface, yes.
Yes, on the surface, of the surface. And right slightly above it was the mandible, correct?
Based on the photographs that I've seen, I was not at the scene.
I understand. But based on what you know,
Yeah.
okay? So in order for the hair mat to be underneath the skull, it's clearly underneath the skull, is it not?
Yes.
Okay. So in order for the hair mat to be underneath the skull, on the floor, something had to have made it either roll there or put the hair in that position, correct?
Yes.
And the duct tape also made its way in that direction with the hair, did it not?
Toward the surface, you mean?
Correct. Towards
Correct.
the surface. Correct. That's what I meant. Okay. May I get the photograph?
You may.
Thank you.
Now, the video you showed, again, of the possibility that that duct tape could have been in that position was quite graphic, was it not?
It was.
Okay. And was it to try and appeal to the jury's emotions when you asked Mr. Ashton to do that?
Objection. Decisions of what may we approach.
You may. Yes. Members of the jury, would you step out for a minute, please? You may be seated. You may proceed with your proffer.
Yes, sir. Dr. Warren, you testified earlier that it was under your suggestion that this movie be prepared, correct?
Yes.
Okay. And when you had that discussion with Mr. Ashton, was it for the purpose of appealing to the jury?
No.
Okay. Was it for the purpose to demonstrate to the jury something of a graphic nature?
No.
Was it for the purpose of getting sympathy or getting the jury angry?
No.
And it was just for the mere possibility of showing that the duct tape could have possibly covered the nose and mouth.
That's correct.
I have no further questions.
Okay. Check and see if the jury's ready to come back in.
I'd like to use a comfort break since we got.
All right, why don't y'all take a 5-minute break and we'll get started at 20 minutes past. State recognized presence of jury.
Yes, sir.
And does the defense.
Yes, sir, we do.
Mr. Baez, you may continue, sir.
Thank you, Your Honor. Dr. Warren, I just have a couple more questions. You're aware that another piece of Henkel duct tape was found 9 feet away, correct?
I was not aware of that.
Oh, okay. Now, the possibility of this demonstration that you did, that was just, of course, one possibility, correct?
Objection. Asked and answered.
Overruled.
One possibility.
The demonstration, the QuickTime video that you did, that was just one possibility. It's demonstrating one possibility, correct?
True.
Okay. And there are other possible scenarios that could be involved with both Caylee's death, correct?
Correct.
And also the duct tape, correct?
In terms of the position of the duct tape over the face, no.
No, what I'm saying is that there are other possibilities, since you don't know the history of where the duct tape was originally, there are other possibilities that could involve that duct tape.
Of course.
Okay. And you don't have any QuickTime movies of those, do you, sir?
No, sir.
All right, thank you. I have no further questions.
Redirect.
Doctor, do you have an opinion as to whether the duct tape was placed on Caylee Anthony before decomposition?
Yes,
What is that opinion?
it was placed on prior to decomposition.
What do you base that on?
On the fact that the mandible was found
Overruled.
Go ahead.
on the position of the mandible still articulated with the rest of the cranium. On a surface deposition, skeletal elements get moved around. They get moved around by scavengers, insects. That mandible will always become disarticulated unless it is held in place by something.
And in this case, can you see anything holding it in place other than the duct tape?
No, sir.
Now, you're not saying the duct tape was actually stuck to the bones.
It was never stuck to the bone, no, sir.
So how does the duct tape during decomposition keep the mandible in place?
The mandible's probably stuck to the soft tissue as well as the hair, and then when the soft tissue decomposes, the duct tape stays in place and supply some sort of support for the mandible.
Now, Mr. Could we have published states 218, please, Your Honor, in evidence? States Exhibit 218, the photograph.
Okay.
Pull it up and make sure. You need the number? It was CS. Now, Doctor, this is the photograph that you were shown by Mr. Bias. I'm going to publish it to the jury now. Is that correct?
Correct.
Now, this photograph shows that the hair, in fact, is not under the mandible, but posterior to the mandible. Is that
Correct. It's under the base of the skull.
not under the mandible?
Correct.
Now, how, during decomposition, does the hair end up not on top of the scalp?
The hair is attached to hair follicles on the galeal or scalp tissue. When that tissue decomposes, it tends to slide down, and so it's not uncommon to find what essentially looks like a bird's nest of hair settled around the base of a skeletal element or skull.
As we see here, around the back of the base of the skull?
Yes.
And is that something you commonly see in decomposition elements where the hair basically just falls back and creates a nest?
Correct.
Just like that?
Yes, hair preserves fairly well. It lasts a while. It preserves fairly well. It lasts a while.
No further questions.
Mr. Bias?
We can leave. We can bring that back on. Yes. Okay. Yes, sir. Thank you.
Publish, Mr. Bias.
Yes, sir.
States 218.
218, sir.
Okay, publish.
Can you see that, sir?
Yes.
Can the ladies and gentlemen of the jury see it? Yes. Okay. Now, there is significant root growth underneath the mandible as well, correct?
I do see some roots there.
Okay. And roots underneath the mandible can also, in conjunction with, well, actually, let me ask you this. You see roots also attached to the hairnet, do you not?
I do.
Okay. The roots could also contribute to keeping the mandible in place, could it not, sir? As it is demonstrated in this photograph.
That's possible.
Yes. Okay, we can publish. And the statement that you say, well, if I can have just a moment, Judge.
Right.
I have no further questions. Thank you, Judge.
Okay.
Does active decomposition inhibit plant growth?
No.
Could those roots have grown?
calls for an opinion outside of this witness's expertise.
This,
Sustain, establish a foundation for him to answer the question.
I'll just move on to another question, Judge.
Okay.
I guess what I'm going to ask you is, can the roots can't grow in the hair until the hair has already fallen off the skull, correct? I think
Sustain unless you establish a foundation as the base of his knowledge and his qualifications to give an expert
okay.
opinion.
Are you familiar at all with plant growth involving decomposition? Is that something you normally see?
Yes.
Okay. You're not a botanist,
No.
but have you had experience in evaluating plant growth in the context of taphonomy of remains?
Yes, and locating graves and changes in the environment in general.
All right. Now, I guess my question is, Mr. Baez asked you if the roots in the hairball could keep the mandible in place. You said it could, correct?
It's possible. I would say roots can would keep a mandible in place under certain circumstances. I would say that's possible, yes.
But what has to happen before the roots can do that in this case? What would have to happen? Does the hair have to first fall off?
Yes.
Okay. My point is, until that point,
Two areas that he covered that I'd like to ask you on. Number one, you're not a botanist.
Correct.
And forensic botany is a whole nother field, correct?
Correct.
And you would defer to a botanist as to those opinions?
Yes, I would.
Okay. Second of all, you can't, based on the evidence, the limited evidence that you have, know the tracking of that duct tape, can you, sir? Because you don't know where it was originally at to begin with.
The tracking.
Yeah, where... You can't testify as to the positioning of the body at any point in time, can you, sir? Okay. And you can't testify as to where the hair was at one time or another.
No.
And all we have at this point are photographs that you've observed of duct tape stuck to hair.
Correct.
No further questions.
Okay, may the doctor be excused.